Hello and welcome to the 7th webinar in our series about Grazier Safety series, presented in conjunction with OB Organic and Grazing BMP. My name is Ross McConaghy and I'll be your facilitator for today. Thank you for joining us for today's session, which will be going through common law claims. The first 6 webinars are now live on our website and will provide the address at the end of today's session. Please send any questions through at any time during the webinar and we will endeavour to answer them at the end. Please also take a few minutes to complete the survey at the end of the webinar, as it provides us with valuable feedback. And any problems accessing this link, please also let us know and I'll give you an email address at the end of the webinar. Your presenter for today is Ross McConaghy, a panel solicitor from Jensen McConaghy Lawyers, working with WorkCover Queensland. Ross founded Jensen McConaghy with Scott Jensen, and together they have built a firm of legal professionals dedicated to fostering client relationships and delivering effective results. For the past 26 years, he has been practicing exclusively in insurance and personal injury law, defending compulsory third-party workers' compensation, professional indemnity and public liability claims. I'll now pass over to you, Ross.
Thanks, Ros, for that kind introduction, and good afternoon, ladies and gentlemen. In today's presentation, I'll be providing a high-level overview of the Queensland Workers' Compensation Common Law Scheme, touching on issues relating to what an injured worker must prove to receive an award of damages, and what steps you as employers can take to reduce the risk of a common law claim being made. Now, in saying that, I appreciate that rural workplaces are amongst the most difficult to manage from a risk perspective. It's often impossible to directly supervise your workers given the areas required to be covered and the fact that they're often working on their own in remote locations. They create unique challenges for employers and also for WorkCover, and in turn us as WorkCover's panel lawyers in defending those claims. In Queensland, our system for compensating injured workers comprises of 2 distinct but related schemes. On the one hand, the no-fault statutory compensation scheme, and on the other, the common law damages scheme, and your WorkCover policy provides cover for both. To receive no-fault statutory benefits, a worker need only establish that an injury was suffered in the course of employment. That scheme provides the worker with weekly income while off work and covers rehabilitation and treatment expenses and the like. And the vast majority of workplace injuries are dealt with under this system and don't move into the common law scheme. There were around 65,000 statutory benefits claims in the 2016 financial year. During the same year, there were about 2,150 common law claims. So there's a very low number of claims that migrate across into the common law scheme. So what is common law? Essentially, common law is the law developed by our court system as distinct from the laws created by Parliament. The courts establish principles, which we refer to as precedent, and that gives assistance in future cases to how they're to be dealt with, subject to statutory modification. In Queensland, we have something of a hybrid model. The common law or judge-made law has been modified to some extent by the legislature, and our courts are now provided with some guidance in relation to how certain principles are to be decided. I mentioned before there's only a very small number of claims comparatively that move from the statutory claim system into the common law system. What's the attraction of pursuing common law damages and what's the catch? Well, first and foremost, the damages claimed successfully from a common law claim are generally much higher than the compensation available through the no-fault scheme. For example, the no-fault scheme doesn't provide compensation for future economic loss, nor for pain and suffering. The catch, though, is that the injured worker must prove that the employer was negligent. So how does one access common law? Well, essentially, for a successful claim, the worker who's been injured must prove that the employer has been negligent and that a number of criteria were satisfied. First and foremost, that there was a duty of care owed by the employer to the worker. Secondly, that that duty of care was breached. And thirdly, that that breach resulted in personal injury to the injured worker. Now, it's firmly established in Australia that all employers owe a duty of care to their workers, and that duty of care is to take reasonable steps to avoid or reduce the risk of injury. That's firmly established now in Australia. So generally, point number one is ticked very early in the piece. That duty of care can't be delegated to another party. So regardless of whether you hire out a worker to another employer or you send that worker off to work at a third party's premises, nonetheless you retain that duty of care, although it may be argued that the host employer or the occupier of the property where that person might suffer injury must also share the burden, but you can't delegate that duty of care. So the real focus in common law claims are on points 2 and 3. Firstly, that the duty of care was breached and that that breach resulted in personal injury. Now, under our legislation, the Workers' Compensation and Rehabilitation Act, a successful claimant must establish a number of things. Firstly, that there was a risk of injury and that that risk of injury was reasonably foreseeable. Now, if you look to the photo on the right of the screen, that's a fairly clear example of a reasonably foreseeable risk of injury. That's a bit extreme, but it puts it in context. The worker must also establish that the risk was not insignificant, that the injury was preventable through the exercise of reasonable care on the part of the employer, and that the precautionary measure to prevent the injury was a reasonable response to the risk. And lastly, the injured claimant must establish that the injury was caused by the materialisation of the risk in question, which is what we refer to as causation. Now, encapsulated within that general concept of the overarching duty of care is a range of, I guess, sub-duties which have been developed by the courts over many years. I've listed a number of them there. First and foremost, to provide, maintain and enforce a safe system of work, to provide safe and appropriate plant and equipment free from patent defects, to provide safe premises, to instruct employees in the safe performance of their work, and to provide adequate supervision and assistance. In a nutshell, the employer's duty is to identify risks in the workplace through thorough risk analyses, to devise safe systems to prevent those risks materialising, to implement those measures, and to train, maintain and reinforce those measures. You can do that in a number of ways, obviously through using written safe work procedures, reinforcing those procedures regularly through toolbox meetings, safety meetings and the like, and by generally promoting a culture of safety in the workplace. So when does an employer breach its duty of care? An employer will have breached its duty of care where the risk of injury was reasonably foreseeable and not insignificant, where there were measures available to the employer to protect the worker from that risk, and where the employer unreasonably failed to adopt those measures. So it follows that not all risks present in the workplace require a response, and ultimately at the end of the day, your duty as an employer is only to do what is reasonable. The law does not expect you to absolutely guarantee or ensure the safety of your workers. The duty is to take reasonable steps to identify risks and then minimise the prospect that a worker might be injured as a result of materialisation of that risk. There's also a balancing act or a balancing assessment that you need to undertake between the cost and inconvenience on the one hand of guarding against a risk as against the likely severity of the injury on the other. If the cost and inconvenience of guarding against a risk far outweighs the potential severity of that risk, then the law generally doesn't require you to take steps to alleviate that. So, as I say, there's a balancing act that has to occur. Now, you as employers might also be exposed to a finding of liability in circumstances where another worker causes injury to an injured claimant. We refer to that as vicarious liability. And also an enhanced duty of care can sometimes arise, which is also referred to as a special duty of care, in circumstances where an employer has prior knowledge that an employee might be at some particular risk. For example, if you have a worker with a known history of lower back problems, the courts will impose on you a higher duty of care to ensure that that worker isn't involved in tasks that might expose the worker to further injury. So, for example, heavy lifting, repetitive bending, or that sort of thing. It may surprise you, but our courts have held on numerous occasions that there are a number of instances that might, on the face of it, appear unfair, where an employer might be found to have breached its duty. For example, where your employee is a very experienced worker and has performed the task many times before without incident, without injury. That may boil down to really being a case of good luck as opposed to good management. Also, where the risk was obvious. The courts have long held in Australia that employers are required to guard against the risk of injury to workers created through inadvertence or complacency or sheer repetition of the task. There's a famous case decided by our High Court many years ago involving a garbage collector back in the old days when they used to pick up the garbage tins and run out to the trucks, and he'd perform that task for 20 or more years and ran around the back of a truck out onto the road and was hit and killed by an oncoming vehicle. Now, that's something that common sense would tell you was an obvious risk, but because he'd done it so many times without incident, complacency and laziness had crept in, and the court found in that case that the employer was required to guard against that risk materialising. Another example is where there's been no previous incidents. You could have had a completely incident-free workplace for many years, and on one occasion you have a worker who suffers a serious injury. Again, that may boil down to a case of good luck as against good management. Where the worker is performing an unauthorised task in some circumstances, that can create a liability, provided that that task is within the general scope of the worker's duties. Criminal conduct on the part of a co-worker or a third party that can create a liability in circumstances where, for example, the employer might have some prior knowledge, for example, of some violent or aggressive behaviour on the part of one co-worker towards another. That can give rise to a breach of duty. Or where, as I mentioned before, the worker's working at a third party's premises or even in their own home. The law requires you to ensure, as far as you reasonably can, that those workplaces are free from hazards. Okay, so I've listed on the next slide a few examples, a few factual scenarios for discussion as to whether or not they might give rise to a breach of duty or not on the part of an employer. The first is a worker who sustains injury lifting a 23 kilogram item of agricultural equipment. I should say at the outset, manual handling cases are notoriously difficult, and the precise facts of each case become very important. For example, a 23 kilogram item for a normal able-bodied male worker probably doesn't present a reasonably foreseeable risk of injury. However, if you combine that with an awkward posture having to be adopted because of a confined space, or a repetitive lift, or a pre-existing degenerative back condition, the outcome can change very quickly. So depending upon the individual facts, it could go either way, and there have certainly been cases involving weights of much less significance than that, which have resulted in an injured worker receiving significant awards of damages. The second scenario is a worker who falls from his horse after the horse becomes entangled in fencing wire, which has been left in long grass near a boundary fence. This is an actual case. In that case, there had been a fencing contractor at the site, and there'd been some coils of wire left behind. The court in that case found that that constituted an unsafe workplace, and that the employer should have taken steps to ensure that after that work had been carried out, there was no loose wire lying around. Now, I mentioned earlier vicarious liability. In the scenario I've given you, I've referred to a co-worker leaving the wire on the ground. That was arguably a negligent act by the co-worker, and the employer is ultimately responsible for that co-worker's negligence. If that wire had been left behind, as it had in the case I mentioned, by an independent contractor who'd come onto the property to carry out the fencing work, the employer still doesn't unfortunately dodge a bullet. It might be though that part of the responsibility can be hived off to the contractor, because as I mentioned before, ultimately you as employer owe a non-delegable duty to your workers to ensure that the workplace is safe. So in that scenario, there would be a reasonably significant finding against the fencing contractor, but you wouldn't avoid liability altogether as the employer. The third scenario involves a pure psychiatric injury, which I must say are becoming more and more prevalent. And in this example, a head stockman verbally abuses a young jackaroo on one occasion. There'd been no prior history of this. And as a result of that, the young worker allegedly sustains a psychiatric injury. Now, on those bare facts, that claim would probably fail, unless it could be established that the employer was aware of some issue between the head stockman and the jackaroo. That would put them on notice that there was some behaviour which they needed to guard against. Now, sometimes, particularly in the sort of work environments that you have in rural areas, strong language is required to get the message across, but that shouldn't be allowed to cross the line to become bullying or harassing behaviour. So again, as I say, that case probably would fail on those bare facts, but if there was a history of some aggression or antagonistic behaviour from the superior to the junior worker, then it would certainly arguably put you on notice as employer that something wasn't right and that steps needed to be taken. Second last example, a jackaroo on a motorbike chasing a wayward calf collides with a wire fence. Again, this is a real case. In that case, the worker sued his employer because he alleged that in the excitement of the chase, he forgot essentially where the fence was. There were no visual markers on the wires on the fence, and that there should have been some warnings given by the employer to remind him that he might encounter paddock fences or boundary fences in the course of mustering activities. That particular plaintiff lost because the court said it was unreasonable to expect that a property owner on a very large property should have to put visual markers every few metres along each strand of wire on each fence, that was an unreasonable response to the perceived risk of injury, nor did the court think that it was reasonable that the employer should have provided a warning to the worker. He was very familiar with the property, knew where the fence lines were, and was just not paying attention. So in that case, the claim failed. And finally, the last example is a young female worker who was thrown from a horse for no apparent reason. And in that case, there was no prior history of any sort of unpredictable behaviour on the part of that animal. Now, in those circumstances, again, the case would probably fail because the employer wasn't on any particular notice of any risk that horse might present. Now, the facts of that case could change very quickly if, for example, there was some history of unpredictable behaviour or aggressive behaviour on the part of that horse, or where, for example, the worker was thrown from the horse and hit her head on a rock or a hidden log in the grass and sustained a head injury in circumstances where it might have been arguable that a helmet should have been worn. There could be a finding in that case that the employer should have enforced a system requiring the wearing of a safety helmet, which I know is a controversial issue at the moment in rural workplaces. But there has been at least one case I'm aware of in one of the southern states where an employer was successfully prosecuted by authorities for failing to require a young worker to wear a helmet in circumstances where he was thrown from a horse and sustained a fatal head injury. Horses are a major cause of death and serious injury in Australia, and that's obviously well known. So courts may well adopt a fairly tough attitude in Queensland, particularly as the benefits of helmets become more known. Obviously a helmet won't assist in relation to a spinal injury or a neck injury, but in circumstances where someone suffered a head injury, fatal or otherwise, there could be a finding for that reason alone. I should also add a note there in relation to what I haven't touched on, which is a worker's contributory negligence. That is where the injured worker has behaved in a way which has contributed to their own injury. The courts do recognise that and will reduce the worker's damages proportionate to that level of contribution. And if, for example, in that scenario, the young worker had been told to wear a helmet, rode off wearing a helmet, but half a kilometre down the track took it off and put her old battered Akuba on, the allegation of contributory negligence might well and truly be made out. Just quickly touching on pre-existing conditions, an employer will be exposed to damages where an incident results in the aggravation of a pre-existing condition, and that includes circumstances where an incident might bring to light a previously asymptomatic condition. For example, a worker with a degenerative but otherwise symptom-free lumbar spine. In a number of cases, the medical specialist will say that the workplace incident has accelerated the onset of symptoms or has brought those symptoms to light when they may not ever have been suffered. The onus is well and truly on the defendant, on the employer, which in turn means me, to prove that the pre-existing condition would have affected the worker in the future had the incident not occurred. And the law requires that the defendant produce medical evidence which, with a reasonable degree of accuracy, identifies when, in the absence of the workplace injury, that injury may have become symptomatic and may have led, for example, to the worker not being able to continue in employment. It's a very difficult onus to meet. In other cases, an employer will be liable where there's an underlying condition that results in the worker suffering a far more serious injury than a person of normal fortitude. And that's what we refer to as the eggshell skull rule. To give you an example, a very simple example of that, you might have a person who is visually impaired in one eye, who, as a result of a workplace incident, sustains a penetrating injury to their remaining good eye. Now, obviously, that injury would have far more devastating consequences for that person than it would with to a person with normal eyesight in both eyes. Now, just to give you a very quick potted summary of how we assess damages in these claims. I could spend hours on this topic alone, but just to give you a very general idea, we break down the assessment into what we call heads of damage, and in the workers' compensation scheme they generally relate to these 5 items. The first is general damages, which is a global term to cover pain and suffering and inconvenience and loss of enjoyment of life and all of those sorts of things. It's the award that is a bit nebulous and you can't really place a precise calculation on. I've referred in the slide to that now being calculated by what we call an ISV, or an injury scale value, under the legislation in both the workers' compensation scheme and the compulsory third-party scheme, and now also in the public liability arena. In Queensland, damages for pain and suffering, or general damages, are assessed by reference to a 0 to 100 point scale, with a 0 injury attracting 0 damages and a 100 point injury attracting a figure of about $358,000. A 100 point injury would be an injury of the most severe imaginable. So it might be, for example, a child suffering acquired brain injury and quadriplegia with full insight into their condition. That would attract the maximum. At the other end of the scale, you might have a worker who sustained a soft tissue spine injury which has resolved with no symptoms at all. Past economic loss speaks for itself. It's really the past loss of earnings and also past loss of occupational superannuation. Future economic loss, which is a little bit of a misnomer, it's not strictly the calculated loss of future earnings. It extends also to the impairment of that person's earning capacity. So, for example, even if a person has returned to full employment on full wages, they can still receive an award of damages for future economic loss, because what the court is compensating is not so much the lost income as the lost ability to earn income in a range of occupational pursuits, and to compensate that person for their risk on the open labour market against other able-bodied workers if, for example, that worker happens to lose their job. Past special damages, which are really just past out-of-pocket expenses, medical expenses and that sort of thing, pharmaceuticals, and future special damages, future out-of-pocket expenses. Okay, so what can you do to assist? We lawyers like pieces of paper. We particularly like pieces of paper with signatures and facts written down. The importance of accurate and comprehensive note-taking and an early incident report signed by the injured worker where you can't be emphasised enough. Now, your first contact with the injured worker may result in the only contemporaneous account of the event, and that is very, very important. Where possible, you should take photographs of the scene where it might be relevant and of any contributing plant or equipment that might be involved, and if you can, preserve any relevant plans and equipment because it may become crucial evidence at a later time. When there's a dispute about the circumstances of an incident or whether it even occurred, a court is going to be highly influenced by what appears in your notes, and ultimately you may be required to give evidence at trial as to the content of conversations you may have had with an injured worker. So early note-taking, very important, and that can save literally hundreds of thousands of dollars in the common law claim. So just in closing, some points to remember. As an employer, your obligation is to analyse your workplace and each of the tasks that are involved in that workplace, to identify any risks associated with those tasks, to devise systems and procedures to avoid or reduce those risks, and then to implement, enforce and reinforce those procedures. It's no good, or it's not good enough to identify the risks and maybe tell the workers about it and then do nothing more. There needs to be a system of continual reinforcement and retraining to ensure the message gets across. And provided you've done that, you've got a much better leg to stand on in establishing that you've taken reasonable steps to avoid injury. And lastly, if an incident occurs, as I just mentioned, document it as soon as possible through contemporaneous notes, photographs, signed statements, and an incident report. And remember always that WorkCover Queensland and its panel lawyers and Workplace Health and Safety Queensland are here to help and provide you with guidance through that process. Thank you for your attention, and I'll hand back over to Roz.
Thanks very much, Ross. So if there's any questions, just send those through and we'll try and answer those for you as quickly as we can. So as Ross was referring to there on the last slide, that it's important to identify the risks associated with the tasks, devise the systems and procedures, and implement and enforce these, and keep your records. And that's what we've been talking about in this series of webinars about developing a safety management system. And you know, just listening to what Ross is saying here, those documents are going to be really important if there is an incident. And so if you haven't had an opportunity to listen to the rest of the webinars, do jump onto our website and have a listen through those, and it'll give you an idea of what you might need to do. And if you have any questions, just get in touch with us on our Agriculture at Justice email address, which is up on the screen now. So Ross, we've got a question here now for our grazing company. Should we have a new employee induction and anything special in an employment contract? Yeah,
that's certainly very important. All new employees should be properly inducted. If you have safe work procedures, for example, those should be discussed in detail with the new employees. I know, because I've been through it many times, that employers will occasionally just hand a new worker a booklet or a set of procedures and ask them to sign, acknowledging that they've read and understood those procedures. It's really not enough. I think you really need to work through those properly, each of those procedures, and get a proper acknowledgement from the new employee that they fully understand the systems that you've devised. Anything special in the employment contract, not particularly, other than an acknowledgement that they've been inducted, that the safe work procedures have been fully canvassed with them, and that they understand those procedures.
Thank you very much for joining us, everyone. As I said, the webinars will be up on our website, and the address is up there on the slide. It's worksafe.qld.gov.au, and if you have any specific workplace health and safety questions, you can email myself at agriculture@justice.qld.gov.au, and we'll try and get some information out to you. If you'd like a copy of the Serious About Farm Safety Guide, which is on our website, but if you would like a hard copy, I can organise to send you that out as well, and that will give you guidance about developing your safety management systems and providing that documentation that we've been referring to today. You can also subscribe to our eSafe. There are 3 rural ones per year, and you can do that through our website. Thank you very much for attending today's webinar.